we prepare, you look at the microphone if it is functional properly, so that the rest of the people can find us moving. We are supposed to have this session in just 1 hour, so it means now that it is 36 past 3, we shall begin at 40 past 3, and we should go through by 40 past 4 for this session. Let me invite Penelope to take us through the profiles of these great people who are going to guide us in the next thematic plenary 2.
Good afternoon. As we wait for let us recognize our retired emeritus principal judge, Justice Bamwine. Ambassador Butagira, we see you again. Before you, my lords, is a distinguished panel for the afternoon discussion, and the topic is commercial energy, construction, and procurement disputes, preventing conflict before escalation. I'll start with Mr. John Kalemera. He's an advocate of the High Court and a procurement specialist. He has worked as a senior legal advisor to the Public Procurement Regulatory Authority, where he played a key role in the preparation of standard bidding documents and the amendment of procurement laws. Between 2019 to 2024, he provided legal representation in 93% of the cases handled in the Procurement Appeals Tribunal. He's a partner in the law firm of Muhumza, Kateva, and Kambanyani. You're welcome. We also have Mr. Alan Wakapopo. He's an advocate of the Courts of Judicature with 20 years of legal experience, 12 of which were in various in-house counsel roles. He holds a Bachelor of Laws degree from Makerere University, a postgraduate diploma in legal practice, and an MBA from Heriot-Watt Business School, Edinburgh University. He's the head of legal services at Umeme Limited and a member of the Chartered Institute of Arbitrators. He has developed extensive expertise in legal and compliance matters within the energy sector. We also have Mr. Kenneth Akampurira. Kenneth is an advocate of the Courts of Judicature. He's a construction and arbitration lawyer, insolvency practitioner, and managing partner at Amber Solicitors and Advocates. He's a holder of a master's degree in construction law, arbitration and adjudication from Robert Gordon University. He's a seasoned lawyer with extensive experience in commercial litigation, arbitration, and finance. He has held various roles related to his expertise in top-tier banks such as the FCU. Moderating this panel, you already met her in the morning session, Asilia, so I hand over to you.
Thank you, Ms. Penlow. Ladies and gentlemen, welcome back from lunch. Your Excellency,
you know when you work with someone, you kind of assume that you have talked about them, but this is a very upcoming powerful woman in her own right. Allow me to introduce in a special way Damali Kateiwe. Damali is an advocate and certified mediator specializing in dispute resolution and conflict avoidance. She is a key figure in alternative dispute resolution in Uganda, actively bringing traditional litigation with mediation and arbitration to solve family and commercial matters. Damali holds an LLM in International Dispute Resolution from the University of London and is a member of the Chartered Institute of Arbitrators in the UK. Thank you, Damali.
Thank you very much. Welcome back from lunch. And in the tradition of Africa, we would allow the guests to speak before Ms. Damali, who is at home. So we'll get right into it. And I will start with Mr. Akampura. What is your advice when people are engaged in construction? How can they use ADR for their construction projects?
Thank you, Madam Silla. I'll be very honest. I think the memo was not very clear, so all of us as panelists, when we sat down to look at our slides, we had so much talk about the law and how these contracts look like, which one should you adopt for which work. And the morning panel really did put us on the pedestal of you're now going to start from scratch. So more or less, I think it's more or less of an oral exam now, so we need to speak off cuff. Construction, on my side as a construction law practitioner, I'll be looking at the FIDIC suite of documents, the red book, the yellow, the silver book, the pink, and then also PPDA form, and the GCC and the SCC. But those don't apply when you come to but I think I need to start again. I need to start again. Why I say they don't apply is we need to get back to basics. So I cannot start talking about the FIDIC suite of documents which are meant for infrastructure development. We do not have a highway that is being put up. We don't have a flyover. Government, of course, is not here today. It's more or less of the business sector and the legal practitioners. I'll start from a place where standard documents might not apply to some of the infrastructure or anything that you want to construct at a business level. There is need for the legal fraternity, in my view, to number one, educate itself on what are the basics or what should be in a contract that relates to construction. Is it like a sale agreement? No. A contract for a home to live in and a contract for a hotel structure like this one are totally two different things. Your home, you have the luxury of having a small contract with your normal mason to help you on the foundation with 2 million shillings. And you take off, then you'll get a contract next door and start another project with your other neighbor, and definitely you'll abandon your works here with your 2 million, you're already eaten it, and goes the other side. The presumption is you have no problem, you'll come back and work, isn't it? You said, but you abandoned my work and now you're going to the neighbor's work. What's wrong with you, man? I'm going to take you to police. And maybe you'll come back or send one guy to put some little bricks and then run away again. While any structure like this one, or even just a small plaza, if you're building like shops in the trading center, money has been put there, money has a time value to it, you're expecting rent at a certain time, maybe you have funding from the bank or from the circle, they expect money in 3 months to start running. So there, the terms change. Building for my home, I can afford to still complain with you. But when I have a loan running, I can't afford to have the same contract I have with the other guy which is informal. So in anything that has any financial implication, please make sure it went. Writing contract for the construction, number one, you should envisage number one day I may have to claim for lost time. Okay? So if you're going to claim for lost time, there must be a clause that provides for when the contract will start and when it will end. And if there is a delay, how do we deal with that delay? So in your contract, you must also have an aspect of, if I have raised all the money and I'm ready to construct my small plaza in the trading center, I want it by the 14th of February 2027. In other words, I will be having Valentine's show. So I have Valentine's at my premise, which means the contract must have a start date, which is today the 5th of June, and by 10th of February next year, before Valentine's, we should be having a handbook site. So you can't have it at large, running as it wants. So which means you must put a clause to it in terms of when does it come to an end. But also secondly, if there are delays in delivery as per the schedule, how do we deal with them? So we must allocate risk. If there is a risk of say for example, there are rains that were unanticipated, you could have our Entebbe saying that there will be rain tomorrow, or there will be sunshine tomorrow, and instead it floods today. So where is that delay going to be put? Are we going to charge you for it? Then there are delays which are really impact, which are by the contractor himself. My material is on site, is fully paid, and he has chosen to take workers on the other side because he feels I'm not on site, so he can go to another site and start working. If I have a contracts manager or a project manager on site, he should be able to give me a report that actually the guys are at work today. If at the end of the month we're supposed to have done the first slab and he hasn't done it, we must penalize the contractor. So delay damages come into place. So we now move to going to court to try and prove the damages and put them on site. So we have special damages on site that at the end of the month we must have a slab. If it's not there, if there is no sufficient cause, the project manager should be able to say, our contract provides for 10% of amount already disbursed shall be delay damages. So immediately there is a punitive aspect to it. That helps you on ensuring that the project is actually progressing, as opposed to our house. Your home, anybody can go to police and have a police matter, stolen goods and things like that. But once the project involves money, there must be a penalty for that delay. So we surpass in two clauses that must be in that contract, and lawyers must be alive to them. Number 3 is the dispute resolution clause. I think that's relevant today. Construction projects are delayed because of the mode of dispute resolution. As an advocate or even as a businessman, you want your money to be working, not seated in the courts. I think this morning we had the opportunity of hearing the numbers in the courts. Around 13 trillion, 14 trillion is stuck in court. Your money cannot be part of that if you're doing a construction project. Otherwise, number 1, you're bound for winding up. Number 2, you're also going to be adjudged bankrupt. They might sue you. Okay, fine, I think time is up. But in terms of dispute resolution, start at adjudication or start at mutual settlement and have that for a small time. But also, you must appoint an adjudicator if possible. Have somebody in mind who will adjudicate the matters. Construction law has now progressed from just having an adjudicator to having also a dispute adjudication, a dispute avoidance adjudication board. That's where we are now on international construction law. In other words, when we enter into the contract, we also need an adjudicator who manages the disputes as they arise. I normally call it the Psalms 23 in dispute resolution for construction. Psalm 23 says, though I walk through the valley of the shadow of death, I shall fear no evil, for thy Lord and thy staff they comfort me, right? I'm now rushing because of time. So appoint an adjudicator if you can. I think we'll appoint an engineer Deo to be our dispute avoidance adjudicator as we start this Cap Small project. So Deo will make sure that every time a payment is about to be paid, it is certified. If there is a delay, we can always manage the delay by asking Deo who has to pay this penalty and it's done immediately because it is still small. Okay? So we get moving along the way.
So the tiered clause in any construction contract should have at least adjudication as your first mode of dispute resolution.
And the timeline. That when the adjudicator receives my claim and that of the employer, in terms of justifying why he hasn't paid me my certificate, within 28 days you should give us a resolution of that claim. And if there's no objection after 28 days, it is final and binding on all of us. So we don't go for arbitration. Are we clear on that one? Have we got it? Then if it is open, we now move into the arbitration side. But try to take advantage of adjudication as a
Dispute resolution mechanism for construction claims. Avoid court, avoid arbitration. Resolve in 28 days.
Thank you very much. Mr. Cleveland. For people who get into contracts with government or government entities, what is the typical dispute resolution process? And how can ADR help to resolve those disputes?
Thank you very much, Celia. Before we dive into that, by show of hands, how many people here are aware of public procurement? By show of hands. Wow, that's a sizable number, and I hope some of them might be in the business community. So before we dive into the dispute resolution aspect, I'd like to very briefly talk about public procurement. So when government entities, and here I'm seeing some, like URSP and Bank of Uganda, want to acquire anything in terms of supplies, stationery, cars, or when we're looking at entities like Ministry of Works when they want to construct roads, districts, municipal councils when they want to construct roads and buildings and other infrastructure, they have to do it through a public procurement process. So if you want to deal with government, if you want to do business with government, you have to do it through the public procurement process. So we have to know about 3 key players in this public procurement process. One, there is a person known as an accounting officer. This accounting officer is going to be in a ministry that will be if you're dealing with a Ministry of Works, for example, you'll have the permanent secretary, who is the administrative head, that's the accounting officer. If you're looking at the Bank of Uganda, their administrative officer is the accounting officer. If you're looking at a ministry, the COW, municipal council, the town clerk. So that is how it operates. 1, you have the accounting officer. 2, you have the body known as the PPDA Appeals Tribunal. It's a very important body when it comes to handling disputes related to procurement. So I wanted to just clear the air by mentioning this so that it is easier as we run through the discussion of dispute resolution. So you, both lawyers and people in the business community, the importance of this is that 60% of government's expenditure goes through public procurement processes, 60%. So that's a lot of business and that's a lot of work. As a businessman, you want to have an opportunity to deal with government. So you need to know how to handle disputes if they arise. Now, the first thing to note is that there are 3 stages at which you can have a dispute resolution process. The first is when government issues what they call a big notice, when it tells you there is this opportunity to do work with us. That's in a big notice which they advertise in the newspaper. The minute they do that, they issue a bidding document. That is the document that details everything you need to know about that procurement. What they want, that is the procurement requirement, and what you as a bidder have to give them. If you look through this bidding document and you see that it is tailored to, let's say, Tom and Jerry enterprises, that they have made it so that only Tom and Jerry can win, you can complain. You can lodge what they call an administrative review complaint. You complain to the accounting officer as the first stage and say, no, we can see from this bidding document you have made it very restrictive. For us, we can't participate. It is only Tom and Jerry who can participate and win. So that's one of the avenues to challenge at that stage. Then two, which is the most common, is when they issue the best evaluated bidder notice. This is where the entity says, Patrick Enterprises Limited is the best evaluated bidder for the supply of stationery at 5 billion shillings. And they said, you, Peter, your bid has been disqualified because you lacked XYZ. So those type of complaints are the most common. And at this stage, you can lodge a complaint, but you must do it within a specific period of time. If you do not lodge your complaint within 10 working days from the date of that notice, you will miss out on the opportunity to complain. There is no room to give you more time. So timelines are very important at this phase. And we also need to acknowledge that the most common complaint by bidders is that the entity did not properly apply the evaluation criteria. In other words, they say we lacked this, but we had it. So that is the most common complaint. But again, sometimes when they are evaluating based on scores, and they have given person X 90%, and they have given you 87%. Many times the person who they have given 87% does not accept that little difference. They think, no, I think they marked me badly. They should have given me more than 87. I cannot lose by only 3 marks. So those are also very common complaints. The third stage of common complaints is where we have ADR. That is after the entity has signed a contract with you, the bidder. After the entity has signed a contract with you, the bidder, now we no longer go through the administrative review process, the tribunal, etc., etc. No. Now it is a contract issue. So there are two things. If in that bidding document they have provided for dispute resolution by way of arbitration, then you will go for arbitration. But if the entity has provided for litigation, then you have to go to court. So it depends on what the entity has put in the special conditions of contract. But before you decide on, actually at the point of contract signature, it's very important for you as a business person to accept that if there is arbitration in this contract, then I am bound by arbitration. You cannot choose to now run to court and litigate. No, you have to stick to what's in the special conditions of contract. So another thing to note is if you're dealing with works, like Kenneth has rightly pointed out, there are two phases. The first is there is a mandatory process of adjudication before an adjudicator, and it is only after you've had that adjudication that you can now go for arbitration or to the courts of law. So works is a bit special. There you have two different tiered stages of dispute resolution. So those are the three common phases in the procurements where you can have dispute resolution. But it's very important to note that time is a very important thing to stick to when you're trying to file your complaints or make an administrative review conclusion. If you're out of time by even 1 day, however good a case you have, you're going to be thrown out. So it's very important to stick to timelines when you're handling procurement disputes. Thank you.
Thank you very much, Mr. Kalimera. Mr. Akakopo, I'm sure in Mara, within the electricity sector, there are always many disputes. Somebody has put a tower on my piece of land, and I don't want it to be there. There are electricity poles. What is the dispute resolution process? other than the normal traditional court system that the business community or lawyers can resort to for electricity sector related disputes?
Thank you. Good afternoon. I think Friday afternoon is always considered the graveyard shift. Thank you. How many of you get electricity services from the national utility? Or how many of you don't actually? If you have your solar system at your home and you don't, and if a person from UEDCL comes, you treat them like a trespasser. And then, has your relationship with your utility always been 100% good? Maybe in your honeymoon phase, you got connected a week ago and you had no blackouts. First of all, the utility that you are, every time you pay your bills, you're paying salaries to everybody in all the utilities. You're paying for the service you render. So technically, it is a public service, and getting electricity is something you pay for, and you actually are the real owners of the utility. I hope you realize Uganda Electricity Distribution Company is probably your service provider. I work for Meme, so I'm free to talk about certain things that I couldn't say last year. So in the last 10 years before the end of the concession, I was running the legal department, and I noticed that there were 5 types of complaints. How many of you have had a pole in your land without your permission? Yes, so that's one. There was always the aspect of someone building a power line, and they call them project affected person. So that project affected person is a stakeholder. How many of you have had your meter blow or your power line taken or you're disconnected without giving permission? So there's some people whose power would be disconnected. That was an illegal disconnection, or a legal one, but which was not properly explained, but it leads to a dispute. How many of you have had power that has destroyed your equipment at home? Maybe a TV, oh, very many. So you'll find that there are certain things. A pole would fall on your car maybe and damage it, then you have to go and get a replacement. God forbid someone you know is electrocuted. We had a case where a transformer actually fell on someone's car. So I used to handle about 200 cases a year. I would close 50 and get 50 new ones. So they say utilities are dispute magnets. So we found that it was not always advisable to go straight to court for 3 main reasons. One, utilities are almost monopolies. You'll find that unless you have your own home solar system, you have to deal with UEDCL. So that relationship needs to be maintained. And if you're always going to court, there'll be a bit of a problem because the utility makes money from what you're paying. So every time you sue the utility and they meet an additional cost, it comes into the tariff, which means you're the one who pays yourself for suing the utility. And then because they're public services, they're heavily regulated. So the government will provide for an intervention where you have different stages before you can go to court. For instance, the Electricity Act was amended in 2022, and before you go to court, you have to first go to the utility. Like you go to UEDCL, maybe your district office, and say, I have this problem, I don't like the bill you've given me, I want to review it. Now there's a process. If you don't like the bill, they ask you, can you see your average consumption over 12 months? If say you've been spending in your business 1 million shillings a month, then all of a sudden they give you a bill for 5 million. They'll say, okay, let's review it. But if you haven't paid your bill for 5 months, and that's the reason why your bill is 5 million, they'll tell you first pay anything that is outstanding. They do an average. So the first dispute resolution mechanism allowed by law is negotiation. Because these are your service providers, you come with a complaint, they actually give them a target of resolving complaints in 30 days. And we used to measure it. So stage 1, negotiation. Stage 2, depending on your bill, they have a regulator called Electricity Regulatory Authority. I think last year they opened a branch So you say you have a bill dispute. The next stage is to go to the Electricity Regulatory Authority and tell them, we have discussed with the utility that you supervise. We're not happy with the decision. This is why. Go to the regulator. Now the regulator's job is to first of all mediate. So they'll call the utility and say, we have this complaint about you, about your services. First they'll check and see, did you respond properly? Did you follow the guidelines for complaints management? Did you address it within 30 days? If they didn't, they can penalize the utility. If they did, they'll come and have a discussion with you where they will mediate between the parties and they could even make a decision. First, they will wear the hat of a mediator and say, we're helping you resolve. If they see that there's an issue that the utility has not done well, they can penalize the utility. So quite a number of people would go to the regulator. Now, if you're not happy with what the regulator says, there's an electricity disputes tribunal. Now, this tribunal is actually quasi-judicial. They have the same powers as the High Court in terms of procedure, but they're a bit more flexible. You don't need to have a lawyer to appear before them. They'll do away with certain strict requirements of say, evidence, and they allow you to self-represent. I know the government has planned it so that they can become an arbitral body. So they want them to act like arbitrators. Their procedure is a bit more loose and easier to deal with for non-lawyers. But they do have the powers of the High Court. So the decision is made by the tribunal, and it is an award that is enforceable, as if you got an award from the High Court. Now, if you're not happy with the tribunal, you appeal to the High Court. So I think because of the nature of the business that you're running, the utilities found that going straight to court could cause problems in terms of cost, time, and the relationship. So if you're in court with your client for 5 years and they're disputing a bill, the bill is not going to be paid for 5 years. So somebody would essentially be, I hope I'm not giving you ideas, somebody would essentially be holding you're holding a payment ransom. So holding you ransom by not paying you because they're in court. So the procedures were provided for by law. So I think I think the electricity sector has a multi-tiered dispute resolution process, where the High Court, which is where most people start, is actually an appellate court. And now most High Courts, when they find a lawsuit, will now tell you, go back to the Electricity Disputes Tribunal, or they'll handle it and say, we'll handle this on appeal. So yeah, so I think, I hope I've answered your question. Is there anyone who has gone straight to court and been allowed to proceed? If they're going against either maybe UMEME in the past or UDCL. Some courts will allow it, but I think the process that they're beginning to adopt is one where they don't hear you unless you've gone through that process. Thank you.
Thank you very much, Mr. Okoko. Ms. Katuhaire, you practice the traditional dispute resolution, as we call it, which is through the court system, but you are also an ADR practitioner. My question to you is this. If somebody has sued a person in court, and the other party keeps frustrating the resolution process, adjournments, after several adjournments, the court gives a judgment, somebody says, I will sue you all the way to the Supreme Court. As a traditional court practitioner and an ADR practitioner, is there any way that ADR can help to resolve such a dispute while it is going through the court system?
Thank you, Shweta. Good evening, everyone. Protocol observed. The question is, straightforward. Of course, as a practitioner, what would you do at that stage? What I would do, of course, I would encourage my client to resort to ADR, alternative dispute resolution, whereby we can start exploring some of the mechanisms that can help us to resolve that dispute that is before court. Even if you are at the level of an appeal, we have been told from the beginning that We can mediate, we can, we can negotiate at any stage where the case has reached. It doesn't matter. So I would encourage a client to enter into negotiation. If negotiations fail, we can go into mediation, which is also a very, a very well-regulated process, whereby it can be by court-annexed mediation under court systems, or where you can use the private mediators, whereby you sit with a private mediator who is a person of your choice, depending on the nature of the dispute that is at hand. You choose the person that you know that has the expertise to handle the issues at hand and be able to help you negotiate or mediate and come up with a resolution which can help you to settle. Because you have moved from one state to another and things are not bringing out, they are not bringing out an end to the issues. So why would you keep on appealing from one level to another whereby you're not going to get the solution very soon? It is my humble appeal to everyone here, even if you have a case right now in court, it's not too late. Especially for us, the business community. They gave you my introduction, but again, I'm a businesswoman, I'm a legal practitioner, and also a businesswoman. And seeing what we go through as business people in courts of law and in our businesses, it's what really made me to venture much into this alternative dispute resolution. It's what we really need as a business community. It's what we really need to interest ourselves in. In business, we say that time is money, but when it comes to relationships, it means everything. If I do business with you today, I would want to do business with you again. So if we keep in court pulling ropes here and there, which means we can never do business together again. So sitting and finding a way in an alternative way other than court, how we can resolve our disputes, it is the best thing we can do for ourselves. It is the best thing we can do for our families. It is the best thing we can do for our businesses and our partnerships. I have seen, of course, as a legal practitioner and also as a person in business, how partnerships have collapsed, how families have been divided, how businesses have been weakened, not because the dispute was really too huge to that extent, but because of the way how such disputes are handled. If you can choose the best way to handle a dispute, which is alternative, not court systems, which are, which bring a lot of stress, which will take a lot of time, you would save that relationship, you'd save that business, you'd save that family relationship. So at that point, I would advise that people really take up alternative solution. As they have been explained, there are different modes. You can always choose which one is the best that suits you at any stage where your case has reached. There is always hope for settlement, for negotiation. Thank you.
Thank you. As a follow-up, when we talk about court-annexed mediation or private mediation, what does that mean to the people who are not lawyers and who do not understand that? Imagine I'm an 8-year-old child. What are these things?
Thank you so much. We have talked about the two types of court annexed is whereby the courts within themselves, most of us who have been in court for litigation, we know people are here talking about we've been going for mediation in court systems, but they are not taking them very serious. Some of them look at it like a stage in a litigation, but it's not actually a stage. It is whereby court is trying to show you, before you come through these long processes of determining your conflict or your issues, can you first go before a mediator and see if you can be able to talk with the person you're contending with and see if you can end up your conflict. So the court-annexed mediation, it is governed by court. The mediators are paid by court. The process starts from court. You must be having a case in court, whereby the court at a certain stage will refer you to a mediator to hear your case, or you yourself at any stage you can ask court to refer you to a court-annexed mediator to mediate your issues. Then when we talk of the private mediators, for example, I'm a certified mediator, but not attached to court. Someone can approach to me and say, I want you to help us mediate our issues, whereby I'm an independent mediator. I will sit in your issues, help you to negotiate. As a mediator, I don't make a decision for you. My work is to help you, the two parties, talk together, be able to come up with an agreed position on how you can end your dispute. What has been the change is that some mediators have been acting as judges, which is so, sorry about that. But a mediator is not supposed to impose a decision or come up with a decision. My work is to help both of you to talk together and be able to agree that this is where we can meet in the middle. We agree to end our issue like this. Me as a mediator, I help to write your agreement and file it in court, and it becomes binding against both of you. Thank you so much, Chair.
Thank you very much, Mamani. Ladies and gentlemen, this morning we realized that the business community has so many questions. There are so many things that we might assume are known that are actually not known. And therefore, for this panel, we decided to let you ask as many questions as time can afford. Bearing in mind that we still have another session. So Ms. Penelope here has told me that we have 10 minutes to ask questions. Right? So please, Ms. Penelope, I will then assign the panelists the different questions. Thank you. We will start with you. Any questions, comments? Yes, your members advocated that you start this session.
Thank you so much. Question to the gentleman from Meme. This is very unfortunate that most of the public service, those who are offering them to us, are as if they are helping us. Like, we give an example of UDCCL disconnecting power or giving us power. It seems as if they are helping us. So when you talk about that we are paying bills and we are paying workers, for them they think we are helping. So you have no actually either to give any complaint or maybe to give any suggestion. And I actually think we should now get down to the public and sensitize them to know that we maybe have to co-work. Yes, they are giving us the service, but we are also paying for it. So they should not assume that they are helping us. But we are also helping them because they can also be having power. And when we're not paying power, then the services will get stuck. I thank you so much for informing us, because actually that is what we didn't do. Thank you so much.
Anyone else with a question? Coming to you, sir, because you approached me in the lunch break.
Thank you, the panelists and participants. Good enough, the convener, if convener is still here, I will send my other request through you. But with women, I'm strong harmony Logarema. senior technician, because I think I enrolled in 201. But unfortunately, when I applied for a job, they told me I was overqualified for their jobs. I had to quit. Yeah, there are challenges in the field that you normally make, especially when it comes to women and this UEDCL thing. The recruits you recruit, the level of understanding, the level of workload that makes Ugandans slaves or dictators in their own things. Like Seth has put it clear. I'm only paying a bill, electric bill. It's more of a service, but not more of a mandatory thing. But your workers were admirable. To the tune that someone made me use the electric power for 18 months because of his unruly conditions. And I told him, because I could not be teaching electricity in a technical school, and he disconnected me. I even went to the manager and told him, I know power more than your boys here, so I cannot live in that class. When there is power here? And I used it direct for 18 months. But because the condition of the technician who had just come to disconnect had put me off to that tune. So I don't know whether the biggest problem in Uganda currently is education and engagement with the service, or between service providers and those whose services go to. So how are you going to handle that? My last question was supposed, but the one I wanted, the chief convener has gone out. Maybe if the moderator will remind him when he comes back. You can't give what you don't have. The judiciary has let us, I mean, you can't talk of the ADF, ADR, or conflict resolution when we see people lost in prisons. There has been a case in prison over 28 years, not appearing before any single magistrate. And the judiciary is just, we have a backlog. We have a backlog. What's that backlog? Then sit with your fellow judiciary members, sit with your other people, advise them. We have a serious case, Peter, that Peter I just highlighted me as I entered. I should ask about it also. So, Mr. Ambassador Sir, having been a Speaker of Parliament, and having legislated and put laws in place, having advised in the Constitution of Uganda, the mandatory bill is partly offline. Why can't the judges, why can't the judicial leaders sit with their own, advise them how to live with those inactivities? Because if a person to the tune of Dr. Bestie can be in prison for 590 days when we have a mandatory bail, it's not an amount of the Hochgambot, but it concerns us all, because mandatory bail is not for Dr. Bestie only. Now, and what you should think about actually, one by one, if they can arrest a bushwalker hero, spend 590 days, what about you, Katema Masini? So, ndugu Speaker Sir, Ambassador Sir, my request to you that you tell your fellow land colleagues in the judiciary that they sit together and tell Wakuma that what he's doing is wrong. Because you can't have peace when the temple of justice is under fire. Thank you.
Yeah, thank you very much. My questions just go to that Councilor Maria, maybe those who can help. There are some situations we talked about these negotiations and all that. But there are some situations you see, at first people are so mad at lawyers, and the good enough were corrected that not all lawyers. I have a situation that some are part of. A certain family sat and agreed and gave a daughter land, and that daughter sold that land. After selling the land, she got in touch with another lawyer, that she was given small land. So that lawyer advised that young girl to take the mother to court, yet the father had died. When they went to court, the lawyer of the mother advised the mother to, there is that something like tenancy in whatever, whereby the title was, they were having the two names of the father of the late and the mother of the girl. So the mother decided to say, no, even the land which I had given you, put a caveat there. Two of them got lawyers in the same family, in the same home. They are just here in Harvard. Now, all of them are not educated. All of them, the only thing they have to use to facilitate their cases in court is the property that the deceased person left. One lawyer tells the old woman that we shall go to court in Pakarasi. The girl got a lawyer and says, if we can win this case, me, I'm going to give you 2 acres of land. So the lawyer has already started his process. Good enough, our Justice Shimi, who helped us a lot in this, is here to hear this. The good enough, he said that now those people have they belong to the Law Society people, so we should not tell him about it. My question is, what can happen to client whereby the two lawyers are using their legal profession to keep pushing the case to remain in court, yet you see the family is reducing properties and becoming more poorer, walking on foot, coming, walking to all the from Biharwe to the court, and the family is suffering, and these lawyers are expanding, both of them are having interests. What can happen? Where can someone go and get help to bring these two lawyers together and tell them about these negotiations? Thank you very much.
Take one more and then they answer.
In fact, Musasa, Baronias, Bamutu Basiji, or sometimes into some present Banji. It took me a man, we have a Yona Gambaho. Council, is it a young man? They are telling Royo Wakapurima, no Zandish. Konkapo kubanozandisho nobanoza kushashura. Twachiri. Wanozandisho nobanoza kushashura. Remember someone, a widow lost her husband. Aina bana babatitire muntu. Sometimes obundo muntu nadanga letters of administration. Hati takicheza bakwata chinchona taini hari hisende abana nibenda kushoma nabo bakija bakabanga ba lawyers hati lawyers babiri bakona hivi ogwayoku bashita mahande in fact njela bazaba mutekuka bajamwe hati bichora kuri goryaho na nubu muriye umwaka guhaza ho bunde bamushanje. I have a sister, a cousin sister of mine. We have worked 7 years.
In fact, kirikunshaasha munonga ekirikukirayo tinikumanya baruyabe kinibasa kukinshobora kuba nahiwa nababonana munonga kifu omukooti omuntu yaza yayina abajulizi bataano ondiijo atiine mujulizi n'omwe omushanga ogucumirwa musimbuwa notiine mujulizi ninga noyina abajulizi bataano hariho obuzibu buriho mazima hariho ekizibu haza nimureba emyaka eyinini abaana baingi mubazaire washanga ori omutambuza omupiipuro nkanye runyamba ngu enyuma iwaho hariho nja kutambuza abaana bawe timanya aho eki ekintu abantu omu mitwe yaabo kitarimu kuza ahantu okaza omu ofiisi noyenda obuyambi hati ekikuuku akakushaba ekituga bazanyoranakangire babaze nanjunwa tinkukikuha oku birabereka beko tinkukakituga hati oriyo wahereza ekituga akaba nibwe yarabaho nomanya bagira ngu otiine sente takusinga mushambo yaba nkwekiri nokoreka omu kukimanya mbwenu nimuteekateeka ngu ihangare ekituga yontutwara nkaye imwe nk'abantu abashaija bainabwe nangwa abakazi bayenda bo bakora konka imwe abashaija abarikugumizamu kureeta ekikururo ky'abaana banyu nyinkakare mwaba mutakiriza abahakuba omwana wagye yatashomire naza kwija kwiba owawe I don't know oba nimwija kukikora muta nebeiba abantu bahansi munonga omuntu obasigira akataka akaguze omushaka tukukubayo ekyo naninshaba mwe ninshaba nkakaba imwe bayuka yomukiseera kigoro yatuka munsimbe munonga ekyo kinanyama
Honorable Justice Bamwine, who has come in, and he's going to speak specifically about something I believe is going to assist with all these other issues that we are facing. And therefore, forgive me for skipping some of the questions. So let me give my panel the questions that they're going to answer. Mr. Kalimera, Mr. Kampura spoke about dispute resolution boards, and I know that you are a construction practitioner as well. Explain to us, as if we're 8-year-old, and very briefly, what is a dispute resolution board?
Thank you, Asiata. So there is a body called a dispute avoidance. And this is very key. Dispute avoidance and adjudication board. Okay? So the first part is the avoidance. So this was introduced in the new, Kenneth explained, there's a body called FIDIC, an international body of consulting engineers that has a standard set of rules which are widely used in mega construction projects. Now, they came up with this new idea that why do we have to wait for a matter to reach the stage of adjudication for us to handle it? Why aren't we proactive? Why don't we prevent the matter crystallizing into a dispute, becoming a dispute? So that's when they came up with this dispute avoidance and adjudication board. So the way it works is when you sign a contract, a construction contract, and and this is usually the large-scale construction contracts, because these dispute adjudication, avoidance and adjudication boards, DABs, are not cheap. So when you're signing your contract, you engage this DAB organ from the point of signing the contract. So what happens is, as you go along with the contract, they will be monitoring and identifying for you potential disputes so that you avoid it growing into a full-blown dispute. So as the potential dispute is arising, they are helping you resolve it so that it does not crystallize into a dispute. That is one of their key functions. The second is adjudication, which has been happening for a very long time. They handle the disputes as the first instance. So think of them like the High Court or Magistrates Court. Before you go to the Court of Appeal, you have to first start down. So with construction, you have to start with adjudication. So they also handle that. When the matter has crystallized into a dispute and it's going to be adjudicated, that body also handles the adjudication. But the key thing to note is now there is actually a body that can prevent you from having a dispute, because they help you see the disputes and potential disputes and avoid them. So essentially that's what the DAB is. Thank you.
Thank you very much. For those of you who are involved in construction, these are also alternatives. Hiring somebody to watch in case a dispute is about to arise, so that you sort it out quickly before it becomes a dispute. Mr. Rakapoko, in addition to being the lawyer for women, I know for a fact you are an ADR practitioner and an advocate of the court. What is your practical advice for family disputes? How can people in practice use ADR to resolve the numerous family disputes? And just very briefly as well.
Thank you very much. There's a judge who said something interesting, where they said, why would you submit a dispute which you carry to a third party who you don't know to resolve for you? So your family members, you've grown up in the same home, and you take your dispute and give it to a third party who you don't know, who you have not chosen. And this was the judge who was asking that question. Why can't you sit down and take control of that process? As interested, there were quite a number of quotes from the Bible. And I was also looking at Matthew chapter 5, where they said, settle matters quickly with your adversary who is taking you to court. Do it while you are still together on your way, or your adversary may hand you over to the judge, and the judge may hand you over to the officer, I think he was sitting back there, and you may be thrown into prison. So, I think the Chief Justice a few months ago said, courts are not dispute resolution fora. You will not find dispute resolution on board. They just adjudicate an issue and make a decision, and the winner takes it over. I don't know whether this is a common word, haro or kurwana chinyakode. At some point you forget why you're fighting, and you just fight. You go to court, you ask the judge, give this man general damages, exemplary damages, and you just want to finish that other person. Now, families are a bit different because you have planned you all together, and we've seen these cases where you look at them and even ask, were you born? Your parents are same. So I think the purpose of this particular session is to show you that the winner is not the one who takes everything. You can win a court case, but you have not resolved the dispute. You will continue with your challenges. And it's important that from a dispute resolution perspective, you look at the end result. If I get a judgment and I make this person gone bankrupt, I may not even get the money that I wanted to get because this person has now got bankruptcy protection. And then the children will have no school fees and I may even be the one to help them. So we've seen disputes between families that have ended with the families being now the family who is your primary defense losing out. So I think if you have an issue with your family, or if you have an issue with a business partner, mediation is the best way to go. Find someone you both respect, have him come and sit with you, go through the process, and both of you should be interested in peace. Just a quick story, when I was a young lawyer, working in-house, there was a lawsuit where we had 2 senior lawyers, and the 2 senior lawyers started quarreling in the room with each other. After some time, my client, my employer, and the other client said, can all the lawyers leave the room? So the lawyers went, we sat outside for 15 minutes, and we came back and said, we have settled our matter. So, like I was saying, just fighting for the sake of fighting, as Justice Chireria said, your ego gets into the way. You act like these people have done the worst thing ever because they're disagreeing with you, and you take over. So I think the purpose of today was to tell you that there is another way. You don't have to win every time. You don't have to have your opinion being the only one, which is hard. And it has been going on since the days of the Bible where they were saying, settle your matters. Try and think about your relationship. Try and think about the things that you have that you can lose, because at the end of the day you will lose. And then try not to burden the courts with things that you can settle yourselves. Thank you very much.
Ms. Katuhairen, again, you practice in both systems of dispute resolution. Somebody asked about a person who has been in jail for 23 years. As a BTR practitioner, how can people who are in jail be helped using ADR?
Thank you so much. This is one of the reasons why we have called you here. The room is not full of lawyers, but generally the public, so that you get information and know how you can have some of these challenges that have been pressing you resolved. For example, to advise such a person, if the matter is criminal, in criminal we have what we call pre-bargain. If you really know that you committed a crime, you can reach out and use the pre-bargain process, where you will, it is also a negotiation between you, the accused person, and then the state, and then you negotiate on the punishment, you negotiate on the custodial sentence. You have your case concluded so that you know how much time you have to serve in prison, and then you will get out. We talked about the issue of Kanyahu here in the morning, where he had to come up and then his issue was sorted because he was able to use the pre-bargain and other systems that we talked about. If it is a civil matter, be interested in mediation. You can initiate mediation through your lawyer or through your relatives. Talk to your relatives if you're in prison, tell them, please, I'm ready to talk with this person. Can we meet and talk about this and have an end to it? Where those lawyers are pushing you, making you that you shouldn't talk, it will end, we are going to, to bring heaven on earth, please. That's why you're here. Get information and know you have the capacity to have your issues resolved by you, the person who is, being challenged by different conflicts. Yes, lawyers, we are good in one way or the other, but where they stand on your way, it's you who is facing the consequences. Come out and be willing to negotiate and have your issues resolved. Thank you so much.
Thank you very much. Mr. Kampura, there was a question on lawyers conniving together, plaintiff, defendant. They work together to make sure that the issue is not resolved. They keep asking, yes, they keep asking for a lot of money. They are working together to defeat their clients' interests.
I've realized in Kampala we chase our clients and hold them like babies because we are scared they will go away. But it looks like it's the reverse when you're here. You have some small goats called lawyers. That's what I'm realizing, because if somebody can decide to tell you, I am in charge of this case, you can't do anything about it, or they go behind you, both the two lawyers, and begin making you some small Frisian cow where they keep milking every year. I think it must come to an end. The law profession is not supposed to be taken as if it's for thugs, honestly speaking. We are supposed to lead by example as lawyers. If the lawyer has become another case for you to handle, because now he ceases to be your lawyer, it's now your case also, isn't it? Because lawyer and vigilating to go. In my view, you have two options. Number one, tungalo yondiri. You might have Stina, or Parmacity. I didn't know. Mbara. Sorry, I'm going to divert from English to this because I can see there's more heat on that side. Mbararo officer ya Law Society. Okay. So Law Society in office can remove section ya legal aid. Once I'm legal aid of a very good and basa okutwala bakuyamba loyoli arugemu ozomugwa legal aid azonga legal aid naye nobuzugwayo noboli amase yaliko ebitine sente zokumukora tuvuka warugari ekyo waratirakorre wazo mukora the next time gambiro muramuzi my lord or your worship nararo yawanje nani nshaba otugaruze wa registrar nanga koti tunzele mediator ba mediator numero 2 aba mediator our court annexed ukaro wasambasha ram nojanyi na mediator alimuramus itumachi that is judge evaluated judge abagambere imwe mukiranga famira aha mwino buzari mazafuteza bitubita kaliyo wanyu nyenda manye teta kaniliaji ili chikatara za kutwara we mushitameje no mwana wananga ngakuba bagambira kwa koze DNA kwa tukore DNA baza tukore DNA ya mwena badra hati nsaga kwa quantities abako bachi kwa mtaro kureba omrazana nachi na maisho ngazanyu na magandi ziri kutandikira kandi zirahendere abana bayamanyire imtego kutsira so mushabe judge evaluated mediation if not babatundire royondijo muka numbasa koshana kada royamebe al senior nango arukore bitaka imweshana bikira kama sheka itakamuza kuliwa tawasinkomo mwanzo mishomra muzi yasishimi mwamshebe kama sina imani mwenda mungu na toda ati mwanzo mediation file ya dekweta ya court ne mara na facts zuru kwa mwine zuru mugambra trawo uzare tuwane regional na nechi chenchumara damta akanwa tukweta kwa file kando mkotelio mkotelio
I'm a victim.
hati milongisha omramuzaria president judge wasi mwamshemere ashikana za kuwachi ashikana za kuwachi wacha ina kwa oramu roya wa ine file soko jana kutambara nayo akashishe dira kakishireka tuko koti na ile file yayo wazo mkoti ukashawa file yao tubatiro mkoti babili yuko ya koti tukuwasa jedote conflict yawe jedote conflict yawe bahandiche itaro ajasishimye Was that you don't know my kind? When I met that young brother, who we live, I reconstructing space. Wonka, I'm just going to still going to go over one. Mugamento na mediator, tunakwenda kuyaitwa hivi. Tunaweza tubasika. Huko mediation, they are parties. Huko kirumsha Mungu pia wao.
That's okay, let me help you that interpreting in your college. As of starting of 1st June, we are going digital. So it means that now we cannot have physical files to be lost. So even your lawyer, what you're going to be doing with them, they have to scan it. So what we shall have is a digital file. So the only that file can get lost is if all the files on the High Court get lost in one computer. Because now everything is just going to be digital. So even if you change your lawyer, or your lawyer says I'm going away, your lawyer can't say I'm staying with your file. Because the file will be online. We're now doing that online. Yes. So we no longer now, we have actually already started. So we don't deal with physical paper. Even coming to court, you'll be coming to court and I'm there with my laptop. As you talk, I type immediately, it goes up. Even if I can't go back and change anything. So that is how it will be. So if at all there is a secretary or a clerk who was supposed to be handling the file and they can enter and do it, the computer keeps a record just like how your phone keeps a record. So it is easy enough to know. But in the past, you would come and they say, I'm looking for my file, and they say, oh, we are very sorry. It was put by mistake in another place. Now that won't happen because it is now all digital. That is a new trend.
Mediator too much mediator. Much
it's also difficult. When I wanted to ask, what happens if a lawyer takes a bribe, like for me, saying, you know, your file has been put on site, now they want to go and see the judge, you can give me like 1 million, they want to face you, that corruption. You talk about that corruption.
My dear friend, number one, I think maybe we understand that properly. We do not have corruption as a judiciary. Now, where I am in Mbarara, I'm not going to first talk about me. If you get a lawyer telling you that I'm going to take money, just know they're deceiving you. 100%. You will be in court, I'll tell you can't mediate or not mediate, you will say you can't do it, I'll make a decision and I deliver it. As a rule, even me in Barara here, my rulings are always in my laptop. They are printed in the morning as I'm going to read it. So if anybody tells you that even has an idea, they are deceiving, not even my wife knows. So let me start with that one, okay? But now the way we're going to do it, since it's going to be online, as the data comes online, now that people think it's being scanned and so on, I won't use any more papers. I'll be sitting in my home, whether I'm here, whether I'm on holiday in Butagira, I just enter the judgment and I send it. At night it comes like an SMS on your phone, Papa. So it hits you left or right, you lose or win. Now, many times when I just come here, we used to have people, especially on issues of bail, you have people saying that maybe there's an issue of money. When you meet people like they say the same. So one time we had an incident where I was reading a ruling. And then I think the people wanted to come, they were very seated behind, very confident, looked like they were going to get paid. And I gave it to them actually. Then I changed my mind. Then I said, the case was difficult, just let give paid. They did have they did fulfill some conditions. And then they complained. When they complained, they said, let's find out. He found out, my lord, the PGA Veritas and my lord, we found out that we have people who used to come and work at the court as assessors. So some people hang around court, somebody gets into the court system. So they had given somebody, they had given the person money. So it became a big case. I insisted, I said I want to see that person should never work here. I had a second case. Again, people came and were about to deliver a judgment. That one actually involved a senior lawyer in Mbara. Senior lawyer said, my lord, I want to see you. I said, what is it? We went to chambers. Now, one of the people, because it was a family matter, was asking his relatives for money and they couldn't give it to him. So we know what he did to get money? Because he knew I had set a date for a judgment that delayed for a couple of years. He said, now, the judgment able to collect, now to collect money, now it was serious. So when I called him, I called the lawyer, I called the lawyer on the opposite side, I called the complainant, and came to chambers. As I said, we don't call an open court, we say we go to chambers. I said, they are saying we brought money. No, my relatives never like contributing money. I have been struggling with this case for 3 years. It has come to this moment and it's some money. I said, but what did you tell them? I told them that it's about getting the mulamuzi. I said to me, he said, no, not you. I said, which mulamuzi then? I said, why did you say your lawyer wanted money? Then they said, if I said my lawyer wouldn't give money. And I said, no problem. We went back and I read the judgment. Fortunately or unfortunately for them, they had actually lost the case. When they finished, immediately, I ordered the police, the court ordered the police who is in court to arrest the person and take them. Now, after that, we had all kinds of people and influence. Police was coming, the people were coming, are connected, there is security. I said, if you release a single person, you will see me. Take the person, charge them, take them through the process. If they're to get bond, let them get bond, and we do that. That's how we reduce a bit of that drama in Barra here, with evidence. So that case, we made sure it went all the way. And I also have to tell my bosses, because people will come and say, we are now sorry as a family, we have resolved. Don't look up our relative. I said, but you're the ones who go to deny a complaint. Why do you want to say I live here? When you live here, people never get to know. So now, you tell your friends, or if you ever hear that they have given money, please kindly, you come and see me. If anybody has a problem, as I said in that matter, I gave you a trick earlier about writing a letter. Nobody can sit on that. But if it fails, I have my bodyguard. You come and say, I want to see the judge on the matter of corruption. Then you will see. Because then the police officer can't hold it back. You understand? The moment we get to know, we find out. But in all the 2 cases I've told you about, one we found an assessor who is not around, we are using, and we fired her. I understand she was well connected, what to who, I don't know. I said we fired, I don't want her near the court. The second one was a litigant who was collecting money from his own relatives because he wanted to return back some investment he had put in. And I made sure the person was charged, and the case went on. I think they finally didn't bring evidence, maybe it was dismissed. But it is there in the records that he was charged. You understand? So follow up those matters. Many of them are not for judicial officers asking money. That is the truth. Yeah.
Ladies and gentlemen, we're going to close this session. But on behalf of the panel, everything about ADR is about mindset change. Lawyers, non-lawyers, all must change our mindsets. Just because it happened last year does not mean it will continue happening. So please, as you go back home today, understand that there is a different way of doing things, whether with the judiciary or with other practitioners. And be willing to change. Don't say these lawyers are always like this. Some are not. Thank you very much.
Thank you so much. Yes, you can do a picture, a group picture there. It's all right. Thank you so much, our panelists. Thank you so much, Saila, for the wonderful moderation of this session. We can give them another hand. We are coming near the end, and we thank you. I have to make sure that I get contacts of these people, because as you heard, there is a lot. So if we have to network, don't go without seeing the Bakoko Takansiga Mshawi in Chikoronda Niwe Kenneth. So now, my Lord PJ Emeritus, we are glad to see you, and we are glad that you listened into this session. My name is Varinda Daudi. I have not introduced myself. I waited for you. I am an advocate here. I am a married man. My wife will stand up, Shamim there. She is also an advocate. I am an insolvency practitioner, certified insolvency practitioner in this region. I also do work, I have a company which relocates remains of the dead. I think I'm the one doing it. Yes, when you want to relocate the remains of your loved ones, you are selling land, I get the court order, I relocate them to a place where you want them. So that is what I do. I am a managing partner of Mugisha Walinda and Company Advocates. I wanted you to know, my Lord, because you came afterwards. Now we are going to the last session. Before I invite Your Lordship, I have been cautioned not to just invite you because some of the people only have heard about you with all that you have done. And they are wondering who is this Justice Yorokamba Mwine. Some of us who know you, who even know home, we gathered these facts and put them here so that we can just briefly tell these people who the retired Honorable Justice Dr. Yorokamba Mwine, Principal Judge Emeritus, is. A distinguished Ugandan jurist and legal scholar who served as the Principal Judge of the High Court of Uganda from 2010 until his retirement in December 2019. He spent 36 years shaping the country's judicial system, rising from a grade 1 magistrate to the administrative head of the High Court and all subordinate courts. Justice Mwine is celebrated as an ardent innovator who introduced systematic changes to address backlog in the Ugandan judiciary. He passionately championed and rolled out the plea-bargaining system in the criminal justice. This initiative cleared tens of thousands of backlog cases and significantly reduced government trial costs. He has chaired the National Task Force that developed and standardized sentencing guidelines for costs. When you mention Justice Mwine, the guidelines, these ones come out very, very, very fast before you even finish the second name. That one will come. As a champion of alternative dispute resolution, he promoted the use of mediation to resolve civil conflicts faster. He's a holder of Bachelor of Laws degree from Akare, a postgraduate diploma in legal practice from the LDC. He's a prominent alumnus of the University of Sydney Law School, Australia, where he pursued further legal studies. Justice Mwine is a holder of honorary doctorate in philosophy and humanities. You are very much welcome.
Thank you so much. Now, how much time do I have? I was told you would finish at 4. It's 5 already. We need to agree. In mediation, you have to set ground rules. So, how much time? This is 5.
Lord, I see the program and given it 15 minutes.
15?
We are being given 45 minutes.
Yes.
So we shall still have 45 minutes.
I think what you do, relax. Relax your mind. Relax your body. Because what I've found you doing here, what you've been doing since morning, ambassador, professor, and everything else. I have a very short paper, 1.5 pages. So it was deliberate because I was told I would be the last one. But before I even look at this paper, allow me to say, if it was not said earlier in the day, that mediation is not about fault finding. Finding fault, you are right, this one is wrong. I'm wrong, this one. Solution, mediation is about finding a solution to the problem. So you must, without trusting more than yourself. That's number one. It's not about finding fault. It's about finding a solution to the problem. I tell people, the world behind us, the growth before us. So forget about I've been in the court for the last 20 years, what next? The growth before us. Number two, what you get at the end of the case, a mediated case, may not necessarily be what you want or what you wanted, but what you can live with. And the live I'm talking about is not L-E-A-V-E. Live. No. It is L-I-V-E. What you can live the court with or the bill. It's very, very important that you bring down your expectations. Now, unwillingness to compromise cases is especially on early age. Grade 1. You shall not more as your principal judge. It is rooted in a number of assumptions. That money will assist you. Money. When you enter that, when you get a lawyer who hears that, yes, because you have said your name, and the lawyer will eat that money, and we still have them around. Then, of course, we have well-connected. If you have a well-connected relative, Justice Alan, and you may get someone going there to explain that. Incidentally, how many mediators do we have around? The ones who are here now. Show of hands, the mediators. Oh, most of them have left. But this bag is also getting to the mediators. For the first time in my life, not about, and it's about a week ago, I was contacted by a lawyer that wanted to see me. He said, fine, that's okay. And when we met, there is a case, there will be a case on part of this conversation on integrating ADR in family and community disputes. I think you changed the topic somehow and included land. But it was too late because I had already drafted my notes. Now, what are the catalysts? Family disputes. We know them. We all come from families. We all come from families. The first one is money. Money should be used to improve lives, to support children. Yes, you need money for fees. To strengthen families and promote harmony in your home. That's what money is for. However, it's a major cause of instability, family instability. Money. Little wonder that the Bible lists it among the roots of evil. If you want to know where it is, 1 Timothy chapter 6, verse 10. For the love of money is the root of all kinds of evil. Some people eager for money have wandered from the faith and pierced themselves with many griefs. That's money. Disagreements over spending habits, inheritances, and ill-conceived entitlements are some of the catalysts of family disputes. Ill-conceived entitlements. This land, which my father has, is mine. Can you imagine someone thinking like that? Over something you never even inherited from anybody. Ill-conceived entitlements. You have some money, but I can assure you all the family members think it's their money. You can't enjoy it alone with your wife or with your husband. It's for the family. Was it me, ma? Dispute. The other one is communication barriers. And these often manifest as generational gaps. What they do. They were still like those of the past, who were also children one time. What this one is saying, it's no point. Generational gaps. Emotional disconnect. You are in the house with your wife, with your husband, but there is nothing you are doing. You can't talk. One you only have to go to the club to meet people there, otherwise in the house. What are you doing in that house? Emotional disconnect and unaddressed conflicts. Thank God. But some people have had fights. We don't have food at home. arsenal before I go to look for food. Those trivial things, in the end, I think there is a singer on there, overcoming these communication barriers requires active listening. Mediators are active listeners. You listen to the conflict. And advise the parties where you can. It requires setting aside dedicated family time and fostering an atmosphere of mutual respect. The other cause of family disputes, life transitions, marriage. You've been living that life of a bachelor, then all of a sudden you get a wife. And the wife starts dictating I want to go out. Where are you? Where are you going? You know, before that, there was no accountability. You are not accountable to anybody. But now there is someone who is a stumbling block in your life. And you never source of discomfort. Divorce, pregnancy, all these things, influx of relatives in a home. These are sources of disputes in homes. Parenting styles, clashes over discipline, methods in the home. And parenting is not easy. Because you can call a child and say, next time you do this, then there are some homes where the mother will say, oh man, I can't monitor your home. That's the source of conflict now. Oh, man, exactly. But my son, and you are telling me, when you check monitor your home, conflict. Extended family, the in-laws meddling in affairs of a couple, especially a young couple or even old ones. The reasons are many, you know them. Then let me look at the community before I suggest solutions. For the community, these are typically caused by a combination of factors such as limited resources, e.g. land misunderstandings on the boundaries. I worked in the Kabale as the chief magistrate. Kabale, the size of this rostrum the brother will kill a father or a brother. Just the size of it. You can't blame them. Water access. I've talked about water, so I'll give you some water. Water access. For people who are still fetching water from the well, some research. Over 85 of our disputes are resolved outside the court. Over 85. So in the courts of law, the ones we are talking about, where just part of the 15%, or even the 10%. The rest can be resolved outside court. And that's why we are here. I want to give you one example of a family dispute. Following court disagreement that ends in a separation, husband and wife disagree on where their 5-year-old boy will live and attend school. 5 years old, the mother cannot talk to the father, and they end up separating. So which school does he go to? That one also becomes an issue. The father alleges that the mother is restricting his visitation and turning the child against him. The mother fiercely alleges that the child is fearful of the father and that visitations are stressful for him. So atakaza kishobero because umwana bakurembishe, the fellow looks where to go, however. Perhaps it is the mother telling the child, that man is bad. Your former husband. But before divorce, you can't say former husband. It's husband for life after all. Now, how can you resolve such? The first option is to take it to court. Though we have very many courts around. These are the ones that they are saying the cases are taking too long. But you can still go there. You can still take your dispute to court. The other option is to try ADR, Alternative Dispute Resolution. To draft a clear, legally binding parenting plan that outlines the balanced custody shape and orders as to communication inter-parties. How do you go about that? It may require a lot of money. You got? Where is the money? Tomorrow we go. Yeah, those are the things that she handles. Mama Boy, I don't know how much you charge. That's for another day, but at least they should try to fast and be discouraged by your charges. If you charge them at all. I believe she does. I hope really good. Oh no, Cora already. So the moment you get a person like that, who is trained, you can go to school, the boy can go to any school around, the father will support that, will provide the fees. And where will he live? With the mother. And when should the father have access? Yes, maybe during vacation. The problem is solved. the night, resulting in sleep deprivation for the surrounding residents. Don't you get those issues? Yes. Of by 8, 9, 10. No, we are saying there is a solution. Get an ADR expert. Get an ADR expert. You see the conflicting priorities. This person wants so nice, like I said, this person has to send children to school. And when you have your own job, I need my sleep. So, in such a situation, you can get a negotiated agreement on permissible operating hours. You get an expert. I think I've cited the Damari, any other, some volunteer, but we need those services. Madam there, we'll assist you. We'll sit with the parties and say, you can play up to 10 o'clock, 11. The problem with some of those agreements is that, I don't know whether you discussed it, some of these arrangements out of court are difficult to enforce. The other one we put up, get away. And yet you have something in writing. I think that's the missing link as far as I'm concerned. I don't know whether the lawyers have thought about it. An agreement like that is not enforceable unless it is before LC one chairman and the committee. So we are looking forward to a time when such agreements will be enforced by the courts of law. For now, the law recognizes resolutions through court-annexed mediation. We've come from far. There was no mediation at one stage. It was not there. We are now there. You saw Justice Kirawire this morning. Let me give you my story. I was a magistrate, chief magistrate, then later judge. Now in 2007, I was attached to the commercial court. And we heard about mediation in USA. So I traveled with Justice Kirawire. And our registrar was now Justice Mugabe. We went to Washington, D.C. and attended a 1 week, I believe it was 1 week, training. It was slightly different from what you have seen here today, because we would have facts. Then one of us would sit in the judgment, would sit as a mediator, would make sure everyone sits as a mediator. That's when I realized I had been chasing wind. A dispute arrived at that way is more pleasant to the parties than the one where you get a judge deciding it after 20 years. Then it goes to Court of Appeal, then Supreme Court, then back to High Court. sit before a mediator and they have a decision. They shake hands. I see people shaking hands before me, embracing. That was before COVID. And before Ebola. Such people will live comfortably together. That was the turning point. Mother was in Washington, D.C. They had a settlement, arbitration, the equivalent of Canada, but it was private. And that's what sparked off my passion for ADR. Thank you. When I came back, I preached the gospel, and then in 2013 we had the rules. In 2014, 15, we started on mediation. I chaired that. I think I've done. But the Gambagambili problem, most people are stuck. They don't know what to do. This lawyer, the lawyers you are talking about, it's because you don't know what battle to press. Aka switch. Abarinda up to 5. Have a good situation in Keju. And you now say, let's get a mediator. Look for me, I will come. Incidentally, that's what I have a function. I was telling Ambassador I have a function tomorrow, but when they suggested something to do with the community, I said, let me go to Mbarara and talk to our people. When mediation is there for all of us. Why choose ADR? The first one is confidentiality. Whereas court cases are part of public record, ADR proceedings are kept strictly private. You will never know what the parties decided in that room. Tomori Chairman. Justice Katurebe used to tell us the story. It was a divorce case in the cabaret, and the judge must have been Justice Allen. And they appeared before him, and the cross-examination started. I think the whole morning was cross-examination. His client, Butagira By the way, it can be rough. But in mediation, I can assure you, nobody gets to know what transpired. Nobody, because of confidentiality. Let me tell you, the law I started 40 years ago. They used to call it collusion. Condonation. It was impossible. But now with mediation, you sit in a room, you agree, sharing the property, you go to the judge and no singer, divorce granted. mukareko mugeze mukaga ngu enough is enough. Tell me whether a judge would refuse to sanction. Mwaboko bemyaka therapy. You have agreed. That's it. It's your marriage anyway. If you are going to talk about mediation, a lawyer will interpret it through mediation. That's it. Cases which are on appeal can be mediated. It was so unlikely, unheard of, for a matter on appeal to be mediated. How? Not the decision of a judge. But now, you can mediate it. The second, why should you choose mediation again? Cost and time savings. Resolving issues out of court usually requires significantly less time and less legal fees than a protracted trial. Nyine kaya obwenje omfumo n'abaturusha. That's exactly what the moment you are in litigation, the lawyer will say, Guma. That is after losing at high court level. Guma. Let's go to court of appeal. Court of appeal. Guma. Oba Guma, which acheza kwa appearing, get some money. To baba kujira mwenza kusikwa judge. Don't they manyangu mulaifu yanje kajasente nyinjezo. Kati utware judge. Nizitware judge. Tizilemo. You don't see it as a judge, as a magistrate. You don't see it. The third one is party control. Instead of judicial officers imposing rigid and predictable ruling on the family, ADR empowers both parties to actively design a tailored settlement that fits their unique circumstances. Kono ye nakushango kwawe bakusaitinge in Kenya, in the USA. Okay, take that route. The judge will write a judgment. It's because ADR, you're the thorough president candidate, doesn't set any president. You don't talk about Manumsha. But with litigation, Justice Bamine, Justice Bamine, who wants to know that information? I tell you this, Ominas. ADR, I bail you out. The last one is it preserves relationships. ADR is much less confrontational than litigation. I've told you, it is not about fault finding, but solution crafting. So you control the problem and you keep together, even where you have been husband and wife, you have separated, you have divorced. Through this one, you can come. Even after divorce. Yes. Then they get back. Think my church parent was at the can agree to set aside the divorce. You see the beauty? They can agree to set aside the divorce. That's what happened until after road, but that didn't go. In conclusion, there is nothing as bad as washing the proverbial linen in public. Feeling that justice has been compromised thanks to bribery. When a judge decides a matter, it used to really make me feel bad. But then, it is expected. So you will listen. But with ADR, but litigation is known for that, really to make parties wash their dirty linen in public. I'm versus which other one? Ruabinini versus those cases are there. Those students, go ahead and go for litigation. Children are protected from emotional harm. That's the beauty with ADR. Children are protected from emotional harm. ADR is also best suited for community good neighborliness and community cohesion, thereby avoiding violent clashes and mob injustice. Practicing ADR no way. Umwana mukuru bamwita church teacher na church hazard. Kitera kiboko, although the law does not allow even the cane, but kitera nalo kimshia mkuu bafude bwera. Tureka niche. It's better than lynching this boy or this person. So if you want your dispute to be resolved, so that you don't want to go to court of appeal, Supreme Court, up to High Court or lower court, ADR is the way to go. But if you want the case to be decided, Justice Shibia writes a judgment, that's a decision which you can agree with or disagree with. So it goes on appeal, on and on, endlessly. They recommend 20 years, 30 years, that's what Mbarara is known for that. Now, I will talk to them about ADR. Love it. Narration is love ADR. Embrace it and practice it. May God bless you.
Thank you so much, my Lord, for giving that experienced address to us. And I think we were worth waiting for. And let's clap for him. I know we are tired. But me, I still wanted more. I will be one of the people to visit you now. become a star. I am not going to waste any more time. Your Excellency, Ambassador, I'm going to invite you to come and probably give a vote of thanks to all our panelists and His Lordship, and close this conference officially.
Let me first thank Pastor O'Neill for that exposition. It was not by accident that we chose him to be the last speaker. You agree with me? Yeah, but yes. Abantu bambaza bingira n'ekibaleka n'ekikulu. Nali nteekateeka ky'olukiiko nti conference nteeka abantu ki era wambuuza ishinzwe Butagira mulemu ki China ikamu kyenge ki wonka society yiteyambalala naye ya Uganda yoni kigira ki nki what legacy can I be? Ngira nikizananye mpayi beba bagamba ko kasheje musirati mwareba ngo kiburu tujye tukuzemo organizing the follow-up, we get this time to be comprehensive, to be dialogue. Our channel and ideas. Chitegese ya tuchitamana barowe, ya tuchitamana watu wote tushiriketi kugamba. I'm going to show you a solution. Me, I believe in dialogue. I can listen, I'm passionate to listen. I believe in dialogue. It helps. Now, just Alan, I want to thank you for being with us and being patient and listening. Thank you, just Alan, for this participation. Now, the facilitators, you can see the range of facilitators, their expertise. Again, they were chosen carefully so that they can leave some message to you. And thank you very much, facilitators. Thank you very much, resource persons, for work well done. Lastly, I want to thank you, participants. We didn't deal with it. My confidence is not misplaced. So we are going to ponder and see a way forward how else can we help this exercise. This will be our task. But I want to thank you for patience, for being patient, participation. Let's hope it has opened the eyes. And please give us some ideas. I'm free. Give me some ideas. Can move things. Thank you very much. Once again, for your attendance, and I wish you well. I now take the pleasure to officially close this meeting.
We shall definitely live at leisure. All the anthems were earlier on recited, so we shall give chance if you want to approach someone from Seho Thank you so much.